Magandang hapon, Pilipinas! Kayo ay nakatutok sa isang special coverage ng TGON NewsRadio tungkol sa desisyon ng International Criminal Court sa jurisdiction kay dating Pangulong Rodrigo Duterte sa The Hague sa the Netherlands. Ako po si DUTERTE at isa-simulcast tayo maya-maya lamang sa ating mga affiliate stations dito sa TVH Group of Networks. Maraming salamat sa inyong pagsali dito sa ating special coverage. Kasalukuyan din po palang nangyayari para po sa mga hindi nakakaalam ang hearing ng House Justice Committee sa impeachment trial ni Vice President Sara Duterte na anak ng dating Pangulo patungkol sa kanyang confidential funds na itinatago di umano, kakatestify lang ni dating Senador Antonio Trillanes kung saan po na siwalat po niya napakaraming pera na itinago po ng dating Pangulo ng Vice President dito sa kanyang account na apparently wala daw siyang cash on hand pero meron siyang nakulimbat na daang bilyon hindi nga alam bilyong piso ng ill-gotten wealth. Dito po maya-maya lamang po ay mag-start na. Ito na po ngayon, nagsisimula na po ang
by a lawyer and myself, Mary Chair Peace Counsel.
nagsisimula na po ang hearing.
Finally, the Office of the
At
Public
tayo
Counsel
po ay
for
makinig.
Victims, please.
Grabowski, legal officer, and myself, Paulina Masida.
Thank you. I take it that the attendees are the same as the ones appearing on the list which the court officer kindly provided to the appeals chamber before the hearing. If the composition of any of the teams has changed, please notify the court officer by email. I note for the record that Mr. Duterte is not present in the courtroom as he has waived his right to be present and the appeals chamber has authorized it. His written waiver has been filed on the record. He is represented by his counsel. Today, the appeals chamber will deliver its judgment in the appeal of Mr. Duterte against the pretrial's first decision of the 23rd October 2025, entitled Decision on the Defense Challenge to the Jurisdiction of the Court, which I will refer hereinafter as to the impugned decision. In that decision, which bears the document number 309 in the case record, the pretrial chamber found that the court can exercise its jurisdiction in the present case over the crimes alleged against Mr. Duterte that were committed on the territory of the Republic of Philippines while it was a state party. This is a non-authoritative summary of the appeals chamber's written judgment in the appeal. The authoritative version is the written judgment, which will be made available and notified after this hearing. Background of the appeal. I will start with a brief background to this appeal. As I have already mentioned, the pretrial chamber issued the impugned decision on the 23rd October 2025. On 14 November 2025, the defense submitted its appeal brief raising 4 grounds of appeal and requesting the appeals chamber to reverse the impugned decision, to find that there exists no legal basis for the continuation of the International Criminal Court's proceedings against Mr. Duterte, and order his immediate and unconditional release. On 8 December 2025, the prosecutor and the OPCV responded to the appeal brief requesting the appeals chamber to confirm the impugned decision. Upon invitation from the appeals chamber, the prosecutor and the OPCV filed on 16th January 2026 additional observations on various issues considered necessary for the proper disposal of the appeal, and the defense filed a response thereto on the 23rd January 2026. The appeals chamber's judgment. I shall proceed to outline the decision of the appeals chamber on the merits of the appeal. First ground of appeal. Under its first ground of appeal, the defense contends that the pretrial chamber erred in finding that Article 127.2 is lex specialis with respect to Article 12. The appeals chamber recalls that in the decision, the pretrial chamber considered the effects of the withdrawal of the Philippines from the statute in circumstances in which the pretrial chamber granted the authorization to proceed with an investigation pursuant to Article 15.3 after the withdrawal had become effective. It concluded that Articles 12.2 and 13c, which I will refer to hereafter as provisions in Part 2, read in isolation, would not support the court's jurisdiction in the present case. However, in the interpretation of the pretrial chamber, Article 127.2 operates as lex specialis applicable to circumstances of a state party's withdrawal from the statute, with the effect that the court retains jurisdiction in the present case. The appeals chamber considers it important to determine the scope and meaning of these provisions, pursuant to Articles 31 to 33 of the Vienna Convention on the Law of Treaties, which require, inter alia, that a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. The appeals chamber notes the wording of the heading of Article 12 addressing the preconditions of the exercise of jurisdiction. Within those preconditions, Article 12.2 stipulates that the court may exercise its jurisdiction if one or more of the following states, i.e., the state on the territory of which the conduct in question occurred, or the state of which the person accused of the crimes is nationals, are parties to this statute. The appeal chamber particularly underlines that this article uses the present tense, which implies that a contemporaneous assessment is required. The appeals chamber rejects the argument of the prosecutor that the use of the present tense may plausibly reflect drafting convenience or even oversight, rather than the introduction of a restriction on the court's exercise of jurisdiction. The appeals chamber observes that during the discussion leading up to the Rome Conference, the adoption of Article 12 proved to be perhaps the most difficult compromise in the entire negotiations. Therefore, it cannot be assumed that this language, which is repeatedly and interconnectedly employed in Part 2 of the statute, can be easily dismissed as accidental. Rather, this wording lends support to the interpretation that the relevant states must be parties to the statute at the time the court exercises its jurisdiction. Articles 11 to 15, all referring to the exercise of the court's jurisdiction, are interconnected and must be subject to a systemic reading. Pursuant Article 12.1, there is a point in time at which a state becomes a party to the statute and accordingly accepts the jurisdiction of the court with respect to the crimes listed in Article 5. From this point in time, jurisdiction exists with respect to the relevant state until the acceptance is revoked by a state party's withdrawal from the statute. However, according to the statutory framework, the existence of jurisdiction needs to be distinguished from the exercise of jurisdiction. In situations of a state party's withdrawal from the statute, these provisions must also be assessed in light of Article 127, which addresses specific circumstances and determines that the withdrawal shall not prejudice in any way the continued consideration of any matter which was already under consideration by the court prior to the date on which the withdrawal became effective. The Appeals Chamber observes that the provisions referred to above must also be interpreted in line with the object and purpose of the statute, which is to put an end to impunity for the perpetrators of the most serious crimes of concern to the international community as a whole, and thus to contribute to the prevention of such crimes. It would be incompatible with this object and purpose to enable a state party to evade its responsibilities under the statute by depositing a written notice of withdrawal once it discovers that alleged crimes committed on its territory or by its nationals are being examined by the prosecution. At the same time, the state's right to withdraw from the statute would not be effective if the court were able to exercise jurisdiction indefinitely, despite the state no longer being a party. The present interpretation ensures an appropriate balance between the ability of states to effectively withdraw from the statute and the responsibilities that states accept upon ratification of the statute, whilst providing a clear timeline within which the examinations must be pursued. The Appeals Chamber now turns to the contention of the defense under the first ground of appeal, namely that the pretrial chamber erred in law by construing Article 127.2 as lex specialis vis-à-vis Articles 12.2 and 13c. In situations involving a state party's withdrawal from the statute, these provisions must be assessed systemically in light of Article 127, which specifically addresses the consequences of such a withdrawal. The Appeals Chamber notes that the defense argues mainly in abstract and theoretical terms, focusing on the principle of lex specialis. However, the key issue in this appeal is not how the principle is classified or applied in theory, but whether the pretrial chamber made a legal error in interpreting the statute. For this reason, the Appeals Chamber finds it unnecessary to address the defense's arguments on the scope and application of lex specialis, as they do not affect the outcome of this appeal. The appeals chamber considers that what is determinative to this appeal is whether the pretrial chamber incurred an error of law in its interpretation of the statute. In the view of the appeals chamber, the provisions in Part 2, read together with Article 127.2, settle the legal regime applicable to situations of a state party withdrawal. Accordingly, the appeals chamber finds no error in the pretrial chamber's interpretation of Article 12.2, as requiring that the relevant state be party to the statute at the time the court exercises its jurisdiction, read together with Article 127, which establishes when the withdrawal takes effect and the regime applicable under these circumstances. For the aforementioned reasons, the appeals chamber unanimously rejects the defense's first ground of appeal. I shall now turn to the second ground of appeal. Under the second ground of appeal, the defense argues that the pretrial chamber erred in finding that a preliminary examination may qualify as a matter under the consideration of the court within the meaning of Article 127.2. The appeals chamber rejects this argument of appeal by majority. Judge Lotkipanidze dissents on this point. His reasons are set out in detail in his dissenting opinion. Therefore, my references hereafter to the appeals chamber shall be understood in light of this qualification, meaning that the relevant findings pertain to the majority of the appeals chamber, as Judge Lotkipanidze is partially dissenting. Under its second ground of appeal, the defense raises 4 subgrounds of appeal. First, the defense contends that the pretrial chamber adopted an overly broad interpretation of the term matter under Article 127.2 and failed to give due weight to other language versions of the statute in interpreting this provision. Having examined the arguments raised by the parties and participants, the appeals chamber finds that the pretrial chamber properly assessed the ordinary meaning of the words any matter under consideration and did not expand them to include a mere concern or thought. Moreover, it did not spouse a particular reference for the English version of the statute. Rather, in accordance with the test set out in the Vienna Convention on the Law of Treaties, it embraced the interpretation that best reconciles any difference of wording in the texts in favor of a broad reading of the phrase any matter. Therefore, the appeals chamber does not discern any error in this respect. Second, the defense alleges that the pretrial chamber erred in law by finding that a preliminary examination renders a matter under the consideration of the court within the meaning of Article 127.2. Having analyzed all submissions received, the appeals chamber also rejects this argument. The appeals chamber observes that the preliminary examination phase has a clear basis in the court's legal texts, including in Articles 15 and 53 of the statute and Rules 46 to 48 of the Rules of Procedure and Evidence. In addition, the specific preliminary examination carried out in the Philippines situation properly qualifies as any matter which was already under the consideration of the court for the purposes of Article 127(2). The appeal chamber notes that in the specific circumstances as detailed in the impugned decision, the prosecutor, A, decided to initiate a preliminary examination prior to the Philippines' withdrawal from the statute, B, publicly announced the initiation of a preliminary examination, C, adopted a number of procedural steps, some of which involved judicial rulings, and D, submitted a request to initiate a proprio motu investigation on the basis of the results of the preliminary examination. As a result, the appeals chamber dismisses this argument. Third, the defense argues that the pretrial chamber's application of the concept of subsequent practice in relation to the Philippines' continued engagement with the court after its withdrawal was legally inappropriate and factually incorrect. The appeals chamber recalls inter alia that in the context of its request to defer the prosecutor's investigation under Article 18(2), the Philippines underlined that the court lacks jurisdiction over the Philippines situation. The appeals chamber is of the view that the Philippines' decision to arrest and surrender Mr. Duterte, as well as its further engagement with the court, is insufficient to support a conclusion that the practice of the Philippines following its withdrawal qualifies as subsequent practice in the application of the treaty, which establishes the agreement of the parties regarding its interpretation within the meaning of Article 21(3)(b) of the Vienna Convention on the Loan Treaties. The appeals chamber cannot objectively discern how the trial could have reasonably reached said conclusion. The factual conclusion reached by the pretrial chamber amounts to an error of fact in the particular circumstances at hand. Nonetheless, this error did not materially affect the impugned decision, as it did not constitute a determinative but rather an ancillary element in its analysis of the pretrial chamber. As a result, the appeals chamber dismisses this argument. And then the fourth subground, the defense contends that a preliminary examination and a decision to open an investigation are definitely not identical, since the consideration of each of them is carried out by different organs of the court and is subject to distinct provisions. The appeals chamber is not persuaded by this line of argumentation. There is no strict separation between the preliminary examination and the opening of a proprio motu investigation, as they constitute two components of an integral legal procedure, without prejudice of the organ conducting the relevant steps. Therefore, the appeals chamber finds no error in the conclusion reached by the pretrial chamber. Judge Lord Kipanidze considers that the pretrial chamber erred in law in its interpretation of Article 127(2), namely that the court can exercise its jurisdiction over the alleged crimes in this case. For the reasons set out in his partially dissenting opinion, he is of the view that the prosecutor's preliminary examinations are not a matter under the consideration of the court within the meaning of Article 127(2). and that a situation is only under the consideration by the court once a pretrial chamber authorizes an investigation into that situation. Accordingly, he would have granted the defense's second ground of appeal and found that the court cannot exercise jurisdiction in the present case. For the foregoing reasons, the appeals chamber, by majority, rejects the second ground of appeal. Judge Lord Kipanidze is partially dissenting. He would have granted the second ground of appeal, and accordingly, he does not find it necessary to address the third and the fourth grounds of appeal. I shall now turn to the third ground of appeal. Under the third ground of appeal, the defense alleges that the pretrial incurred an error of law in interpreting that the term "the court" in Article 127.2 include the office of the prosecutor. The pretrial chamber noted that the word "court," which is capitalized in this article, refers to the institution of the International Criminal Court as per Article 1 of the statute, rather than the judicial chambers. It further considered that, as stated in Article 34, the court is composed of 4 organs, including the office of the prosecutor. The appeals chamber observes that, in line with the interpretative methodology required by the Vienna Convention on the Law Treaties, the pretrial chamber first considered the ordinary meaning of the word "court." Noting the ambiguities in the ordinary meaning of the word, the pretrial chamber then considered the context of the term in the statute as a whole, as well as by reference to the context in which it is used in Article 127 itself. The appeals chamber finds that the statute employs the term "the court" in distinct senses, and it must be ascertained which one is appropriate with respect to the provisions under interpretation. Having considered the analysis of the pretrial chamber, particularly regarding the context in which the term "the court" is used in both the statute and in Article 127, the appeals chamber considers that the defense has failed to show how the pretrial chamber erred in finding that the term "the court" includes the office of the prosecutor for the purposes of Article 127.2, and therefore the appeals chamber rejects the third ground of appeal. I now turn to the fourth ground of appeal. Under the fourth ground of appeal, the defense argues that the pretrial chamber erred in finding that the object and purpose of the statute permits the opening of an investigation even after the effective withdrawal of the Philippines from the statute. According to the defense, in adopting its legal interpretation, the pretrial chamber made a policy-oriented determination. The appeals chamber cannot discern any error in the pretrial chamber's interpretation of Article 127. The appeals chamber is not persuaded by the defense's submission that the one-year withdrawal period under Article 127(1) sufficiently preserves the statute's object and purpose, as the prosecutor may seek an investigation within this period. As noted above, if the prosecutor is satisfied that a reasonable basis exists to open an investigation proprio motu, he or she is under the obligation to present an application for authorization to do so to the pretrial chamber. The continuation of the preliminary examination past the one-year withdrawal period is reflective of the balance found by the appeals chamber between the responsibilities that states accept upon ratification of the statute, including the aim set out in the preamble to put an end to impunity, and the ability of the states to effectively withdraw from the statute within a clear timeline. The appeals chamber further notes that the pretrial chamber's assessment of certain facts led it to conclude that there is a direct relationship between the prosecutor's announcement of the opening of preliminary examination and the decision of the Philippines to withdraw from the statute. The defense contends that the pretrial chamber unduly relied on a subjective political critique. However, in the opinion of the appeals chamber, the pretrial chamber interpreted Article 127 in line with the methodology set out in the Vienna Convention on the Law of Treaties and its discussion of the Philippines' potential motivations for withdrawing from the statute did not form part of the reasoning contributing to its legal interpretation of Article 127(2). Rather, having explained why the object and purpose of the statute also supported its interpretation of Article 127, the pretrial chamber merely referenced certain facts to provide an example of what Article 127, read as a whole, is designed to prevent. Therefore, the appeals chamber considers that the defense has failed to demonstrate that the pretrial chamber committed an error of law and rejects the fourth ground of appeal. The appeal chamber, by majority, as a conclusion, Judge Orquipanise, partially dissenting in the second ground, has rejected all four grounds of appeal. Having rejected the entire appeal, the appeals chamber considers that the defense request for the immediate and unconditional release of Mr. Duterte is moot. In the appeal pursuant to Article 82(1)(a) of the statute, the appeals chamber may confirm, reverse, or amend the decision appealed. In the present case, the appeals chamber by majority confirms the impugned decision. Judge Orquipanise appends a partially dissenting opinion. This brings us to the end of the summary of the appeals chamber's judgment of today. Finally, I would like to end by thanking all the parties, participants, and their counsel, registry staff, and interpreters who have assisted with today's hearing. There is a lot of work that goes on behind the scenes to ensure that these hearings run smoothly, and the appeals chamber is very grateful to all of those involved, including to IMSS, for its efforts to make sure the courtroom's system are available for the present hearing. Finally, I would like to thank my colleagues, the judges, and the appeals chamber's staff for their support. The hearing is adjourned.
All rise, we will obey.
At natapos na nga po ang pagbabasa ng sakdal dito sa sa jurisdiction kay dating Pangulo Rodrigo Duterte yan sa ICC, sa International Criminal Court sa The Hague, sa the Netherlands. Rejected po ang lahat ng mga appeals ng depensa laban sa jurisdiction sa dating Pangulo at ngayon po ay mananatili siya sa kanyang pihitan dyan sa Schengen, dyan sa the Netherlands. Abangan niyo po ang magiging coverage po ng TGON News Radio sa pagbabasa naman ng sakdal sa kanyang confirmation of charges dito sa International Criminal Court. Diyan po muna magtatapos Duterte sa ICC, ang TGON News Radio special coverage ng pakasaysayang pagdinig sa kasong crimes against humanity ni dating Pangulo Rodrigo Duterte. Ako si Midori Tachibana. Magandang hapon.